any in the appeals keen on the application of P, G and W and of P, and in the matter of Lorraine Gallagher?
Lady, overnight we drafted a short note on government responses to the recommendations to the changes to the criminal record regime, which I hope speaks for itself. We've also added one page, which is the government's response to the recommendation in the Lamy review.
Yeah.
That's not in the bundle.
Right. And this is presumably, the note is agreed, is it?
Well, it's not objected to. It's simply a recitation of government responses and references to where the various documents are within the bundle.
Thank you very much indeed, Mr.
It will be transmitted electronically.
Yes, we will ensure it is.
Thank you very much.
Added. Yes. Thank you.
Yes, Mr.
My Lady, my Lords, I have the privilege of going last, and with that in mind, I'm fortunate to be able to say that many of the points at issue have already been raised, and I don't seek to take this court's time by rehashing or attempting to rehash any of them this morning. Can I say that I adopt gratefully the submissions of my learned friend Mr. Southey on the question of in accordance with the law and necessity, and likewise we for W adopt the submissions made by my learned friend Mr. Owen and the written submissions of Unlock, because of course W, like G, was a child at the time of his offending.
He was 16, wasn't he?
He was 16, yes.
G
Older than G, therefore,
Yes.
but still under 18. What I propose to do this morning, and I anticipate that it can be completed, I hope, within half an hour, is to very briefly, and I mean a 5-minute summary of our case, and then address 4 specific issues shortly. As far as the summary is concerned, the respondent W is now 52 years of age. He has one previous conviction, indeed it's his only involvement with the law, from November 1982 when he was 16. That was a conviction for assault occasioning actual bodily harm, for which he received a conditional discharge and was bound over to keep the peace. That conviction, of course, was spent some many decades ago, but must still be disclosed. It's our submission that neither the automatic and mandatory disclosure of that conviction on any CRC or ECRC under the Police Act, nor the mandatory requirement that W disclose that conviction to any prospective employer by virtue of the 1975 order is in accordance with the law. Further, alternatively, the admitted interference with his Article 8 rights under both parts of the revised scheme is not necessary in a democratic society. Dealing first with in accordance with the law, we say the test to be applied was set down by this court, crown the application of T, and in particular is found at paragraph 114 of that judgment. In summary, there must be safeguards that have the effect of enabling the proportionality of the interference to be adequately examined. We submit there are no such safeguards in this case, as there is neither any mechanism for individual consideration, nor alternatively any sufficient calibration of the filtering scheme, as the Court of Appeal put it. Paragraph 119 of T we submit does not set down a test to be applied in future cases, and properly understood the application of the paragraph 114 test to the facts of T. There is, we submit, no need for this court to revisit the Strasbourg case law. T is binding and has not been appealed. Applying that test as we do at paragraph 38 of our written case, we submit clearly the interference is not in accordance with the law. As regards the 1975 order, again properly understood, we submit that order involves the use of personal data by the state. While the state does not disclose the personal data itself, it has legislated so as to require the individual to make the disclosure effectively for it. The result is exactly the same, that the information is compulsorily placed into the public domain, and that follows from state action in our submission.
Well, it hasn't legislated in order to require this. That there is no statutory requirement that the question be answered. Of course, there are irresistible practical reasons for doing it, but the basic propositions of law involved are, one, that there's no law against asking about convictions, and two, that at common law you can't tell lies.
My Lord, we submit that that is correct until 1974, at which point, of course, the Rehabilitation of Offenders Act is brought in. That creates a right not to answer the question strictly correctly, if I could put it that way. There is then further government action with the passage of the amendment, particularly in this case, the passage of the amendment to the 1975 order coming into effect in May 2013.
It says on occasions you can tell lies, but the basic rule, if you're not within one of those exceptions, is derived from the common law.
My Lord, we submit that there is a statutory rule which in 2013 the state chose, in effect, to set to one side. With the passage of the amendment order, the state reimposed, in effect, a requirement to answer the question. The decision to bring that common law back into effect was a positive action on behalf of the state in our submission. In any event, we submit.
How did that involve your Article 8 rights? I mean, that's what I'm finding to get my head around. Is it contrary to your Article 8 rights to fail to provide protection against telling a lie?
It is contrary to Article 8 rights, we would submit, to require an individual to disclose personal information. There is a right to privacy and private life under Article 8, we would submit.
Yes, but here the right is one created by the Rehabilitation Act.
Indeed, yes, it is.
Not by the Article 8 or by the ECHR.
It is, but that right is then taken away in certain contexts, and is taken away in our context by the amendment to the 1975 order in 2013.
And do you say that T proceeds on the basis that there is an interference with Article 8 rights in respect to the 1975 order? Or
T certainly does, because T goes on to find that that interference is not necessary and it's not proportionate. I accept that Lord Reid in T did not regard the two questions as being straightforward, as we set out in our printed case. My Lady, my Lords, dealing with the question of necessity and proportionality, we submit that the appropriate test is that set out in Bank Mellat, the four-stage test, and it's our submission that the revised scheme fails both the third and fourth stages of that test. The third stage, we submit there are realistic and viable alternatives that are less intrusive. You've heard a great deal about them, and I don't propose to relabour those points. As regards the fourth stage, we submit the fair balance test is clearly not met for a number of reasons. Dealing first with the individual facts of W, we submit that it is plainly disproportionate to disclose an offence from 35 years ago, committed when a child, for which a conditional discharge was received.
Well, what would be proportionate, Mr. Offer?
On the facts of W, or in general, my Lord?
What would be a proportionate rule about the time that needs to pass before a conviction for assault occasioning actual bodily harm ceases to be disclosable?
My Lord, I would submit that a proportionate rule, and this is my own. My Lord asks for my answer, so I give it.
Well, yes,
but
I do, because,
yes.
I mean, is it the more accurate question, I suppose, is it your submission that we should devise that period?
No, my Lord.
Right.
What I submit that this court should do is declare that the scheme as it currently stands is disproportionate. The appropriate answer is for the legislature.
difficult. And that's a problem, isn't it? One sees the sort of agonies that's been gone through by in the affidavits to try and produce a scheme and all the different views which have been taken into account. And you're saying, well, too bad, they haven't got it right, send it back and then let's try again. But we've got to give some sort of guidance, haven't we?
Well, my Lord, yes.
Supposing it was 20 years. Just supposing that there was a 20-year.
For W, I wouldn't seek to argue against that for obvious
Would you not?
reasons. His conviction's over 30 years old. I don't
Oh, well,
need
yes,
to do
of
so.
course. But that's, yes, all right.
Ultimately, this debate is about whether it's justifiable to have a bright line rule. If it is justifiable to have a bright line rule, there will always be cases where one's instinct is that it's tough that this particular case should be caught. If, on the other hand, you want you could either want the bright line drawn in a different place, in which case it's legitimate to test your submission by asking where, or else you want no bright line rule at all and an ad hoc assessment in every case, in which case you have to answer the issues that have been raised about practicality.
There are, of course, other ways.
Yes. Well,
There are other ways altogether.
There are other ways of cutting that cake.
Well, I don't submit that an ad hoc assessment in each case is necessary. There are possibilities here that have already been aired in this court, that a right to apply to have one's conviction rendered non-disclosable, perhaps after a given period, could be done. My Lord is not, therefore, I suspect, strictly correct in characterising it in that way.
I mean, that is this is, I suppose, a hybrid. You would say that you can have a hybrid, you can have a bright line rule, but with a French-style system under which you can apply to a judge to have your record expunged.
Well, yes, that again, on behalf of W, would be an adequate answer.
And it wouldn't have to be necessarily to a judge. It could be a Northern Ireland type scheme.
It could be to an independent monitor or reviewer. There needs to, we would submit that a mechanism which allowed for individual consideration of the case at some stage would be sufficient. My Lords.
And necessary by the sound of it.
Yes.
I do submit that in this case, yes, it is necessary. I don't shirk from that. My Lady, my Lords, we submit that looking at this case on necessity, the first point that we do make is on these facts, and I submit that that's not a complete answer. I don't for a moment suggest it is. On these facts, it is plainly disproportionate. To suggest that W's conviction should still be disclosed is, we submit, almost to deny the possibility of rehabilitation. And we respectfully submit that the Secretary of State almost admitted as much on Tuesday, when, in respect of the position with the employers, this submission was made, that these cases were precisely the sort of ones where one could expect an employer to take a reasonable view. If it is right, then, that the interference can't be justified on the individual facts, the next question is, can it be justified to disclose because ABH is always a serious violent offence? My Lords, my Lady, we submit not, because either, whether you approach a serious violent offence as in some way defined by the Criminal Justice Act 2003, and this is paragraphs 80 to 83 of our written case, or in its ordinary natural meaning, paragraphs 84 to 86, the answer is that whilst some ABH offences are such, not all ABH offences are serious violent offences. If that justification falls away, the next question is, can disclosure be justified on the basis that this is an offence of violence? And again, we submit
Hang
not.
on, while we're thinking about what a serious violent offence is, what about malicious wounding? Section 20.
My Lord asks, I take it, is malicious wounding a serious violent offence?
What's your submission?
Does he have to have a submission on that?
Well, I would say, well, my Lord,
I'm trying to test how one goes about any definition, if it is accepted as an acceptable or objective to define serious offences, how one does it.
my Lord, I would submit that properly charged, in many cases, a malicious wounding of Section 20 would probably be, in the vast majority of cases, be a serious violent offence. However, I'm conscious that not all offences are properly charged, and there are occasions when the matter goes to court that the court, having assessed the individual seriousness of the offending behaviour, comes to a view, often expressed in its sentence, for example, by way of an absolute or conditional discharge, that this was not, in fact, the appropriate approach.
Yep.
And although, by accident, a wounding has taken place, a break to the skin, on those facts, a conceivable argument might be raised, and properly raised, to say that there would need to be a right of individual review in those circumstances.
I follow. Thank
So
you.
bright line rules must not be drawn at a high level of generality or abstraction. They must, if they are to be acceptable, address, to some extent, the individual circumstances of the case.
Well, if I can answer it in this way, what do we say about bright line rules as this? there is no freestanding right to a bright line rule. A bright line rule is an incident at the margin of appreciation. It's a recognition in our submission that a proper bright line rules can on occasions provide certainty and have value for that reason, and they are necessary and can have value because they allow for practical administration. We readily accept that. I don't seek to say that a bright line rule could never be permissible. I accept, as my Lord knows from our written case, that the Court of Appeal's example of a murder conviction being disclosed where somebody seeks to work with children or vulnerable individuals is a defensible bright line rule. However, we say this: when considering bright line rules, they are always subject to the caveat that the rule must satisfy the fourth stage of the test set out in Bankman, the fair balance. Simply saying this is a bright line rule is not an answer, because there isn't a freestanding right to bright line rules. My Lady Hale expressed this well in the Tigere case, tab 22, the electronic reference is page 922, paragraph 37.
We've been taken to that, haven't we?
You've
I
taken.
don't want to be further embarrassed.
Well, that particular bit wasn't quoted, but you have the reference.
Sorry, give us a reference again.
It's tab 22, paragraph 37. The electronic page is 922. It's simply this. Baroness Hale said this: even if a bright line rule is justified in the particular context, the bright line rule chosen has itself to be rationally connected to the aim and a proportionate way of achieving it. See, for example, Crown on the application of T, close quotes. We accept that bright line rules are not necessarily invalidated simply by the existence of a hard case. The question is in the round, as Lord Bingham put it in the Animal Defenders case. The test is beneficial, again, effectively a recognition that the fair balance test is what must be looked at. And for the reasons we give in our written case, and they're set out in some detail there, we submit a fair balance has not been struck in this case. That brings us back to the summary, because we submit that the interference in this case can't be justified on the individual facts. It can't be justified by an assertion that ABH is always a serious violent offence. It cannot be justified on the basis that it is an offence of violence, because, as this court knows, not all offences of violence require disclosure. Common assault does not, unless, of course, a prison sentence has been imposed. And as we demonstrate in our written case, there are situations where the difference between an ABH and a common assault can be no more than chance. In our submission, therefore, the appellant's justification must be that it is legitimate to disclose every conviction for assault occasioning actual bodily harm, because some are serious and some aren't, and they can't tell which is which. Effectively, it's a we cannot do better submission. We submit that that should be rejected for two reasons. Firstly, because alternative and more sophisticated schemes are possible, and you've been addressed at great length about them, and I don't seek to reiterate all the points already made. And secondly, in our submission, because the appellant has not produced the necessary evidence to make out the assertion that because of volume, those schemes cannot be implemented in the United Kingdom. I'll come back to that in a moment, in England and Wales. Finally, we submit that even if those submissions are not decisive, the appeal to resources and practicability made by the appellant still has to be balanced, applying the fair balance test against a number of other important features. They're set out at paragraph 103 of our written case, and we submit that those are features which again clearly indicate that the fair balance test is not met. My Lady and my Lords, I've now failed to do a 5-minute summary, but I propose to move on to the individual issues quickly. In accordance with the law, I'm not going to attempt to repeat my learned friend Mr. Southey's submissions or those in the written case. I seek to make one specific point. It involves considering what we understand the appellant's approach to the test here is. And by the test we mean this: what test or yardstick does a court considering a scheme of disclosure apply when determining whether an interference is in accordance with the law? Our case, of course, is that the answer to that is paragraph 114 of T, the test being, are there safeguards which have the effect of enabling the proportionality of the interference to be adequately examined? And we submit that is supported by authority. By contrast, we submit, it is hard to discern what the appellant in fact says the test is. It appears, as we understand it, to be based on paragraph 119 of T, and my learned friend Mr. Southey laid emphasis on the cumulative effect of the factors set out within that paragraph. We submit that that is problematic. If one considers and
I
tries
think it was
to...
Sir James Eadie rather than Mr. Southey.
I do apologise. I'm most grateful, my lord. If one considers paragraph 19 and attempts to distill a test from it, then logically we submit there are three possible answers. First possibility: to be in accordance with the law, the scheme must comply with all of the factors listed, including the requirement for an independent review. That's not contended for by the appellants and can be therefore dismissed. Possibility number two: to be in accordance with the law, the scheme must comply with any one of those features. That would not make sense in our submission, not least because the word cumulatively is used, and indeed the appellants lay particular stress on it. We don't therefore understand possibility two to be the appellant's case either. We do pause at this point and note that the serious offence rule is one which discriminates on only one ground, the nature of the offence committed, and therefore is not a cumulative discriminator case. Possibility three in our submission: there must be compliance with more than one of the features, but not all of them, to be in accordance with the law. The difficulty with that is it raises another question, which is why? Why might discriminate on the basis of more than one of those factors mean that an interference was in accordance with the law or was not? In our submission, the only possible answer is because reliance on a set of those features might be that there are safeguards which have the effect of enabling the proportionality of the interference to be adequately examined. It might provide the procedural protection required by the in accordance with the law test. And that, of course, brings us back to where we say the correct approach starts, which is paragraph 114 in T. Without that reference back to 114, in our submission, paragraph 119 becomes little more than a random list of possible criteria. And I say possible criteria because it appears to be the appellant's case that the factors set out in paragraph 119 are neither exhaustive nor prescriptive. I get that from paragraph 12.1, section 6 of the Notice of Appeal, core volume tab 1, pages 5,773 to 774 in the electronic. It's clear from our submission, therefore, that the analysis that the test is in paragraph 114 is correct, and applying that test as we do at paragraphs 36 to 8 of our case, we submit that this revised scheme is not in accordance with the law. On margin of appreciation, I make one very short point indeed, and it's to re-emphasise a point already made by my learned friend Mr. Southey, which is that the appellants are effectively prevented by authority from making their submissions. The appellant says that you should accord a margin of appreciation to the state when considering the in accordance with the law stage. That is not a course which is not open to the appellants, and we submit is not open to this court by virtue of the authority of Crown on the application of T, in particular paragraph 115 of that judgment. And it is our understanding that the appellant has yet in its submissions to explain how it is that that paragraph 115, can be put to one side. On bright line rules, my lady, my lords, I've addressed you on most of the points. There's one final point to make, which is this. My learned friend Mr. Southey very properly emphasised the risks yesterday of seeking to draw analogies from cases in different areas and dealing with different scenarios. That's particularly important because in support of the position on bright line rules, the appellants cite a number of cases which relate to social welfare legislation and the allocation of scarce resources within it, cases such as Carson, RGM, Matheson. In our submission, those are poor analogies, because in cases concerning challenges to the allocation of social welfare payments, the state has a particularly and exceptionally wide margin of appreciation. In those cases, the test is the manifestly without reasonable foundation test, derived from Steck in the United Kingdom, and my lady, my lords will find the reference to that, if necessary, at tab 117 of the authorities, paragraph 52, page 4329 of the electronic materials. In a case where the manifestly without reasonable foundation test applies, the fair balance test is, of course, relatively easy to meet. It's certainly as easy to meet as it ever is. In our submission, the situation here is exceedingly different. The protection of personal data is of fundamental importance to persons' enjoyment of Article 8 rights, and the margin is correspondingly narrow. We make that point and support it with reference to authority at paragraph 103, subparagraph 1 of our case, which is page 6067 in the electronic materials. And there's reference to the ECHR authorities in support of that proposition there. My dear Lords, the final point I would make comes to the question of statistics and workable alternatives. The appellant seeks to support their appeal for a margin and the need to bright line rules by an appeal to resources, and in particular, you are asked to reject any comparison with the Scots and Northern Irish system, because it's said the English and Welsh system is different in terms of volume. In our submission, the appropriate starting point is to note that it is for the appellant to make good that assertion. We get that from the judgment of Lord Phillips on the Crown on the application of F, which is cited in our written case at paragraph 100, MS page 6066, electronic pages again 6066. F itself is in the authorities tab 17, volume 2, and the page is 734 in the electronic material. At paragraph 56 of F, Lord Phillips said this: "No evidence has been placed before this court, or the courts below, to demonstrate that it's not possible to identify from among those convicted of serious offences at any stage in their lives, some at least who pose no significant risk of reoffending. It is equally true that no evidence has been adduced that demonstrates that this is not possible. This may well be because the necessary research has not been carried out to enable firm conclusions to be drawn on this topic." And these are, and we submit, are the critical words. If uncertainty exists, can this render proportionate the imposition of notification requirements for life without review under the precautionary principle? I do not believe that it can. In terms of the question of volume, then, we don't ask you to resolve the question. We simply submit that this question as to whether the volume of cases makes it impossible or perfectly possible for a different scheme to be adopted is not capable of clear resolution on the basis of the figures you've been given. It is for the appellant to prove the case, and the appellant has not done so. In those circumstances, the invitation to reject the Scottish and Northern Irish comparisons on grounds of volume should be declined because it's not been evidentially made out. The appellant's evidence we do submit is inadequate to show that these alternatives are not workable. It's right to say that you have evidence from Alison Folds and John Woodcock. Alison Folds at Appendix 2D, tab 117, page 7385, and her second statement, Appendix 2E, tab 126, electronic page 7653. John Woodcock, Appendix 2E, tab 124, page 7628. But all of those statements, although they raise queries about the validity of methods of filtering, do not, in our submission, when looked at carefully, deal with whether or not alternatives such as those in use in Scotland or Northern Ireland could be put in place here, because they neither address the relative resources in the respective jurisdictions or the administrative workability of such an approach. The closest that any of those statements come is the bland statement at paragraph 26.5 in Alison Folds' first statement, that there would be significant resource implications for the police, but that statement is not further specified or developed. We submit that that is not sufficient evidence. Beyond that, the appellant relies simply on figures given to you in terms of the volume. We simply say that evidence as to the raw volume of applications doesn't assist without information about the volume of resources, civil servants, police officers, etc., available to process it. By way of example only, a relevant figure that you do not have is the workload per head of staff who would be available to process such applications in the different parts of the United Kingdom. There are other gaps in the appellant's evidence when concerns ECRCs. I don't ask this court to seek to resolve this question. What the court knows is that the substantial majority of certificates are ECRCs, about 90% of the 4 million. And we know from the evidence of Samuel Ray, Appendix 2E, tab 130, paragraph 21, electronic page 7706, that in 2014 to 15, just under 10,000 ECRCs had material added by the police. What we do not know is how those ECRCs are processed by the police. We do not know how many applications for ECRCs receive individual consideration by the police, and we do not know how many more such applications would require individual consideration if a particular amendment to the revised scheme were adopted. The evidence that you have raises other questions which certainly cannot be answered by the appellant. It's right to say that Clan Child Law, paragraphs 51 to 53 of their submissions, that's pages 76 to 77 of their electronic bundle, say that the volume issue may not be as critical as the appellants suggest, and note that for some years Disclosure Scotland appears to have been able to run its own scheme, plus handle approximately 1.5 million English and Welsh applications, although I hasten to add that those seem to have been basic checks and therefore presumably took relatively little in the way of resources to establish. You've already been referred yesterday at some length to the National Police Chiefs Council's view, and you were referred yesterday by my learned friend Mr. Owen to the Unlock briefing, filtering of records from DBS checks, tab 152, volume 15, electronic and paper reference 5353. We simply say this: if the Home Office has not yet assessed the costs of discretionary filtering, how can it be submitted to you that in the absence of an assessment of those costs, such a scheme is not administratively workable? We do ask you to note Unlock's point on self-financing and ask you to note that the addition Unlock propose, there is no evidence in response to this, is a 50p increase on a basic cost paid by an employer already of either 26 or 44 pounds per application. We re-emphasise that we do not ask you to bring order out of the chaos of the figures. We simply submit to you that you should reject, in the absence of the point being evidentially established, you should reject the appellant's assertion that the volume of the applications in England and Wales means that alternative schemes are not workable. It has not been established or made good. The very final point we make relates to figures, but it's this: the appellant again suggests to you that this is really about a small number of hard cases at the margins. We respectfully submit, once again, that the statistical material to support that has not been provided to you. And we submit by way of one example only that a look at some of the figures provided by Unlock demonstrate this is clearly not so. At tab 151, page 5300, in the Unlock document, A Life Sentence for Young People, a report, the figures given, if I read them correctly, relate to childhood criminal records disclosed in the last 5 years. It says this: the majority were over a decade old, 87.8%, 850,925 of childhood convictions disclosed were over 10 years old. Overall, 81%, 898,289 of childhood criminal records disclosed were over 10 years old. Nearly 500,000 childhood convictions disclosed were more than 30 years old. Given the points made to you by Mr. Owen yesterday in our submission, on any view, that is not a small number of hard cases at the margins. My lords, that completes my submissions with only one additional point, which is this: unusually, in relation to costs, and I think I need to raise it because of the practice direction 6.7.1, W's case is not one where costs follow the event. There is an agreed position, you'll be glad to know. Let me explain. W originally had legal aid funding.
Well, we have that.
You have that. The position is that there is a the permission to appeal was conditional on an agreement that the appellant pay W's costs in this court, limited to junior and solicitor
Yep.
at agreed rates.
Yeah, we knew
So,
that.
Yes, I'm grateful. I simply raise it because the practice direction, I think, requires me to do so.
I'm not sure that is, in fact, it's one of those practice directions which is more honoured in the breach than in the...
I appreciate that, my lady, and I'm very grateful to be told I'm wrong.
Thank you. Thank you
So I
very
guess
much,
it's further.
Mr. Robb.
Thank you.
Now, Sir James.
My Lady, my Lords, I'm going to reply on 4 or 5 areas. Firstly, interpreting T and MM and the correct approach in principle. Then I'm going to spend a little bit of time on the position, secondly, on the position of employers within this scheme. Then easy to come up with alternatives that would work fine as the third topic. Then Mr. Owen and the position of children, and then finally and briefly remedy. So interpreting T and MM, first of all, Mr. Southey asserts that T decides that there is a principle in play in this context that requires an ability built into any system of the kind that we're considering that must allow for individualized consideration of proportionality. And I put it that way deliberately, individualized consideration of proportionality, to encompass both the extreme submission, individual consideration in every case, and what was described this morning as the hybrid position, where a review system is introduced. He says that is a necessary component of any feature of any system in this context. And that, he says, is the true meaning of Lord Reed's judgment and the true meaning of MM and the United Kingdom in Strasbourg. That was, in a nutshell, if I've understood him correctly, the issue of principle that my Lord Carnwath identified when I was opening this appeal. And we make the following submissions in answer to that contention. Firstly, if it is right, it would exclude the operation of schemes set up on the basis of rules or structural bright lines, if that requirement in principle exists. And that would be, we respectfully submit, a big and thoroughly novel and controversial principle. And given that characterization of the principle, it is inconceivable, we respectfully submit, that it would not have been stated in the clearest terms in the case law establishing it, whether it's T or MM. And our respectful submission is that there is nothing in the ECHR case law, including Rotary, on which Lord Reed, you'll recall, relied in T, or in the domestic case law, to support that as a proposition of principle. Secondly, it would, we respectfully submit, that the existence of any such principle be entirely inconsistent with a whole line of cases of high authority. Gochran, for one. Cat, for another. W, in the Court of Appeal, Bundle 3, Tab 23, for a third. And can I briefly ask you to take up W again? Bundle 3, Tab 23, it starts on MS 944. And I want to just remind you of 3 paragraphs, without reading them out, but just so they're on the radar. I took you, in opening, to paragraphs 76 and 77 on MS 964 under the heading In Accordance with Law. And the reason I simply go back to those paragraphs is not to reread them, but to invite you to note that this case was decided as it was, in other words, structural bright line scheme, with no application, as it were, for individualised or discretionary review built into that particular part of the scheme. And in doing so, the Court of Appeal, headed by Lord Dyson, took note of and applied both CAT and paragraph 31 of my Lord Hughes's judgment in the Beggle case, as you see over the page, but nevertheless reached the conclusion, despite those which my learned friend Mr. Southey
prayed in support of his submission that such a principle of individualised review was a necessary component of the scheme. Evidently, the Court of Appeal disagreed because they took into account both of those cases and still found the scheme compatible. The other paragraph I just wanted to remind you of was paragraph 86. And I remind you of it simply because my learned friend, I think, took you to paragraph 85, and I think it's maybe quite important to read both 85 and 86 together in assessing how it was that the Court of Appeal reached the conclusion that they did in that case, namely that a scheme which was based on structural lines was compatible. So the second submission is, if my learned friend is right, he is entirely inconsistent with at least those three cases. Thirdly, we respectfully submit, Lord Reid in T does not set out on any fair or proper reading of his judgment any such principle. And we do submit that paragraph 119 of Lord Reid in T provides the dispositive reasoning in that case. All of the earlier paragraphs in his judgment feed into that concluding paragraph, and it identifies a series of things that were wrong with the then regime. It draws on MM, as you will recall from the judgment, we don't need to go back to it, and it takes paras 206 and 207 of MM, you'll recall those are the two paragraphs Lord Reid quotes, as being the key paragraphs. And I emphasise that fact because it's important to see precisely how those paragraphs express matters, and they by and large do so in very similar terms to 119 in Lord Reid's judgment. But I emphasise those two paragraphs in particular because in my learned friend Mr. Southey's submissions yesterday, he sought to portray, as it were, 204 in MM as the critical paragraph, and then rather jumped past 206. And of course the difference between the two is that 204 suits his case rather better than 206. But anyway, 206 and 207 are the paragraphs quoted by Lord Reid, and they lead to his concluding paragraph 119. We do continue to rely upon the critical wording in 119, which is cumulatively. There was something of a light-hearted exchange between my Lord Kerr and Mr. Southey in relation to this point, but it does, we respectfully submit, for all its light-heartedness, reveal something of a fundamental difficulty in my learned friend's reading of the T case. And that is because it was necessary, in essence, for him, as we respectfully submit, to mischaracterise my submissions as being sort one problem on the list and it all goes away. And that is, in effect...
it wasn't in the least light-hearted. In fact, it was in your favour, Mr. James.
It was, which is why I'm so cheery when making this point.
You were no doubt taken by surprise. But
No. But the difficulty of my learned friend Mr. Southey, of course, is that he has to characterise cumulatively in that way because of the fundamental difficulty that the ordinary and natural meaning of cumulative creates for his case. We respectfully submit that cumulatively means when taken together. And the implication, of course, of that natural meaning is that one cannot assume, at the very least one cannot assume, that all of the factors which are cumulatively taken into account are individually to be regarded as sine qua nons of compatibility. You can put the same point a slightly different way. If, in Lord Reid's view, it was a necessary component of a structural scheme in every case to have a right of individualised review built in, the last of his cumulative factors, it would have been the easiest thing in the world for that paragraph simply to say so. All that was needed was to say, well, this scheme fails because it simply doesn't have the capacity through a system of review of individualised consideration. And he doesn't say that at all. What he says is, here's a cumulative list of reasons why this case is problematic. And of course that's relevant because the scheme has moved on considerably since then. And there is no sensible explanation
for the word used and for the list of factors that Lord Reid carefully sets out in 119, if my learned friend Mr. Southey's contention is right. So that's the third submission. The fourth submission is that context is indeed all. The problem in T was that the scheme had precious little differentiation. It was, if you will, just like the pre-Gochran system considered by the European Court of Human Rights in S and MAPA. And of course, the scheme has now fundamentally changed in all the ways that you're well aware of. So the submission is that there is no requirement in point of principle for a system of individualized review, as opposed to setting up structures which are, in effect, bright line structures. And I note finally on this point, before coming very briefly to bright line schemes, I note finally on this point, is there a requirement for an individualized system of review that the respondents are on this issue of principle, in effect the appellants, because the Court of Appeal below found in our favour on this point. See paragraph 124, which makes that expressly clear. We are not saying, said the Court of Appeal, that you need a system of individualised review. And for good measure, and perhaps it is worth going back briefly to this, so did the Court of Appeal in T. If you have volume 3 still to hand, and you go to tab 20, you'll find the Court of Appeal's judgment. 819 is the start on the electronic, and the paragraph I want for this purpose is paragraph 43 on MS 839. Sorry, 838, para 43. Could I just invite you to remind yourselves of that? The key point is in the second sentence. Sorry, give me that paragraph again. 838, para 43. A proportionate scheme would not require individual consideration in each case. So we respectfully submit that you can have a bright line scheme which does not have built into it individualised review. There's nothing inconsistent in T with that proposition, even if that bright line scheme interferes with convention rights. And of course, the position with bright line schemes, as you are well aware, is that their essence is that lines must be drawn somewhere in a system operating at this volume across this range. And as with all such lines, it is at the very least difficult, if not impossible, to test the lines by reference to outlying cases. The lines simply assume that there will be outlying and difficult cases. And the risk, of course, is that if you seek to introduce a need to test exceptionality, you undermine or defeat the purpose of the bright line in the first place. All that is necessary, we submit, is that it should reflect a difference between the substantial majority of people on either side of the line. And the last 30 seconds contains nothing original. It is all taken from, in particular, Lord Hoffman's judgment in Carson, and indeed from the analysis and the difference, or the differences that existed in this court in the Tijeri case. And I do very briefly want to go back to that, if I may. Tijeri, if that's the right pronunciation, is in the same bundle at tab 22. It starts at page 907 in the electronic numbering. And there were, in effect, and if I can summarise respectfully, given the number of members on this court who were also on that court, there were, in effect, 3 schools of thought.
That's true.
And sparing my lady...
You have all 3 of them represented.
You do. Sparing my lady's embarrassment, her approach was, or is to be found in the combination of paragraphs 36 and 37.
As the only person who wasn't represented.
Well, my lady, my lord, can I just invite you to cast an eye down 36 and 37 to get the flavour?
Yes.
I think the distinguishing feature is that my lady introduced an inclusionary and exclusionary principle and was rather keener on the idea of a review than perhaps others.
I mean, is there a prevailing view in this?
I'm about to make that submission, but you better see it first, just in case I get the prevailing view wrong. But it was my lady and, it was my lady and my lord, Lord Cairn, together, who were responsible for 36 and 37.
But you don't disagree.
Slightly curious.
It's on our records.
It's on your records.
the
Forever to be cited.
I mean, the first sentence of paragraph 37, is that, that's all right, is it? I mean, that was what was relied on. You have a bright line rule, provided the...
It can be rationally connected to the aim and proportionate way of
You
achieving.
don't quarrel with that.
As I say, I mean, it may well be that there isn't an enormous amount of difference between the various views, but they are different at important points, at least.
Well, we reach different conclusions about.
Yeah, I'm not going to have the temerity to suggest that where those differences actually lie. But 36 and 37...
Why not? We can't decide this case without knowing.
36 and 37, all right, I shall be bolder. 36 and 37 is the first view. Can I jump a bit forward then to the second view, which is Lord Sumption and Lord Reid, and the essence of that, which is explicable on the basis of which my lack of originality is mostly explicable, 97 and 98 on MS 942. So that's the other view, rather more forgiving of bright lines, might be thought, and relying on Lord Hoffman in Carson. And in the middle, Lord Hughes, and the furthest I'm going to go by way of submission is that Lord Hughes, we respectfully submit, was rather closer to, in terms of the principle at least, to the Lord Sumption and Lord Reid view. And the essence of my Lord Hughes's approach is to be found, I think, probably in 59 and 60 on 928. Which then leads to 64 and 68. So it's really 59, 60, which contains the key analysis of principle, and then leading to the conclusion, so far as relevant, 64 and 68. And I respectfully submit rather closer to the 97-98 view, I respectfully so submit, because Lord Reid, if I've understood the judgment correctly, would have been forgiving of a bright line rule scheme, but wasn't convinced on the facts about the bright lines that had actually been drawn. And so particularly on this issue as to whether or not review needs to be built in,
rather closer. My lords and my lady, those are the relevant bits of the judgments, and you'll have to consider which way those work in this case. But those are the Tigeri, on rereading it again last night, is perhaps rather closer to the issues in this case than it might have at first appear, at least in terms of those principles. Can I move to the F case? You'll recall the F case, that was the sex offenders register case at Bundle 2, tab 16, and I'm not going to invite you to turn it up, but we respectfully submit in relation to the F case that it doesn't materially advance or assist in answering the questions that you have to answer here. It does not say or establish any general principle that powers of review are necessary in a necessary component of any lawful scheme that interferes with Article 8 rights, and it does not so imply. It was a very specific context with a very specific reason for review. And that very specific reason was that the key issue was whether a sex offender, by definition, remained an indefinite risk. That was the issue that arose in that case. There was some material to suggest that they did, and the argument that was therefore made was that that rendered the review unnecessary, and that was why the key issue was described as it was in para 52 of that judgment. And once that went, it followed that the time might come when the risk needed to be re-evaluated. That was the issue in that case. But it was not a review examining Article 8 balances and all of that. It was a very specific issue, and we respectfully submit doesn't materially advance matters in this case. Mr. Southey then made a series of submissions to the effect that margin or respect has no place in the present context. Conspicuous, it might be thought, by absence from any submissions of any of the respondents is a single reference to the rights of others. And of course, you will recall that the essence of this scheme is precisely to protect the rights of others. And that fact is critical, we submit, to the balances that are struck. The system can properly and should properly be precautionary, because the scheme is trying to protect those who are least able to protect themselves. And the scales, we respectfully submit, are not evenly balanced. This is not, you could be forgiven for coming into this appeal and listening to the respondents' submissions, this is not all about the Article 8 rights of those who find their criminal past embarrassing. And it is critical to margin and to respect, because the context is one which weighs competing rights in the balance. And it is for those reasons that the right issue we respectfully submit for the court is whether the rule, and I take this wording from the Animal Defenders judgment cited by Lord Dyson in T in the Court of Appeal, see para 40, probably a convenient place to get it, judged in the round is beneficial. That's the question. Or, and it's to the same effect, 125 of Essen Marper, which we saw on Tuesday, cited in Gochran at paragraph 24, does the scheme, quote, fail to strike a fair balance between competing public and private interests so that the state has overstepped an acceptable margin? And again, Animal Defenders at 110, quoted in Gochran at paragraph 45, describing what they put as the central question as being a slightly different aspect to the issue now, not whether less restrictive rules should have been adopted or indeed whether the state could prove that without the prohibition the legitimate aim would not be achieved. Rather, they said, the core issue is whether in adopting the general measure and striking the balance it did, the legislature acted within the margin of appreciation afforded to it in turn of Animal Defenders, and we respectfully submit that is the issue. And of course, you know in relation to margin that the scheme is no longer, on any view, properly characterised as being an indiscriminate blanket scheme. And so far as respect is concerned, and the respect that is to be afforded to the judgments of Parliament in making the sort of assessments that are inherent in the structural lines that they have drawn. There is nothing in response to the principled submissions that I made about respect properly being accorded to the choices made and inherent within those lines, even if ultimately lawfulness and the lawfulness question is a binary one. And Mr. Southey advanced no theory, no submission on why judgments about elements of the scheme, ABH, rather than some other list of offences above it or below it, about how the court could go about making those sorts of judgments. He simply ignored that principal submission. Other aspects of the right, Mr. Southey did make some play in relation to that, in particular P having to reveal mental health issues. My short submission in relation to that is that that is simply an integral part of any system of this kind. It is embarrassing, no doubt, to have to reveal past wrongdoing, and equally a person may need to or may choose to explain the circumstances of the offence and thus reveal further personal or embarrassing information in doing so for the purpose of explaining the nature of the embarrassing conviction or caution. But that would be so whoever the explanation was given to, and it is not a feature, we respectfully submit, supporting an individualised system or a system of review. Can I turn to the position of the employers, my second main topic? The employers, of course, are now at the end of a discriminate, non-blanket set of filtering rules, unlike the position in T, where they sat at the end of something which was far broader, far less discriminate, much more readily characterised as blanket. And those rules that now exist are nothing like the position, therefore, that was under consideration in T and in MM. And they go, as I've already submitted, considerably beyond the position that was found to be compatible in Gochran. I do not accept, therefore, that one can in effect properly ignore employers engaging with relevance and significance issues. I do not accept, therefore, that there is some burden to filter out more or to introduce some form of review. And of course, the risks with filtering out more are that you go too far the other way and over-filter, thereby potentially and importantly undermining the fundamental aim of the scheme, which is to protect the weak and the vulnerable. On the contrary, we submit that the employer's role is a proper part of the regime in circumstances in which it is impossible to devise category differences that can determine relevance for particular posts, as the evidence makes clear. So one needs the employers and their contribution, and the consequence is that systemic or automatic filters need to allow through potentially relevant information, or put another way, information that is capable of being regarded as relevant by a reasonable employer. And that's a perfectly reasonable and rational design for a system on the basis that it is for employers to consider the information and to be able to discuss and ask questions of prospective employees. They can be expected to understand relevance and are best placed to assess it. You do not need, and no one I think asserts the need for, a scheme in which there is a legal requirement to consider relevance, in effect precluding discrimination. I think that was the thrust of my Lord Sumption's questions, precluding discrimination on grounds of a conviction. You couldn't sensibly design the scheme that way. And in those circumstances, at most what the state can do as part of this scheme is to provide guidance. And there are elements of the England and Wales scheme which are of interest in that respect. You have the codes of practice that go to employer and other interested organisations. I took you to the 2009 one that was appended to the Folds witness statement, I think the first Folds witness statement, and I friend Mr. Southey gave you the 2015 one yesterday, which was the more recent one. But they include requirements on employers to act fairly, and in particular to discuss matters the word discuss is used in both, discuss matters with the prospective employee, and the desirability of having employer policies, see folds 2. And all of that is backed by the possible sanctions, the codes point out, of deregistering bodies or employers under the scheme. True it is that the concerns about employers' reactions have been raised in more than one forum. They were raised by the Justice Committee, to which my learned friend Mr. Owen took you, and were responded to by the government. Can I just invite you to turn that up? It's Authorities Bundle 13, tab 137.
Tab which?
It's 4918 on the electronic. And whilst that's being done, could we hand up a raster? There's a few documents I want to refer to in the course of this, if that could be handed up whilst you're turning that up. So 137, and the relevant paragraph for our purposes is 49 on 4918. I'll explain the significance of that little clip. I'm so sorry to hand up more, but they are an attempt to be responsive to some of the questions that the court's been asking. So, but you'll see that 49 in the response to the Justice Select Committee is of some interest perhaps here, because it's a public statement of the sorts of factors that should be taken into account by employers. And it might be thought, at least looks pretty similar to the sort of factors that you had in the Gallagher Code, the Northern Ireland Code that my learned friend took you to the other day, which was at 8542 in the electronic. That's the Northern Irish Code in the Gallagher Core volume. But that's 49, that's the government's response to the Justice Committee. And whilst you're there, and so I don't have to go back to it, you will see, I'm afraid it doesn't help you very much, but you'll see the nature of the response to the Law Commission on 4913 within the same government response to the Justice Committee's report, recommendation 10 on 4913 and para 31. And one of the documents that you have in the little clip I've just handed up, I think it should be marked 4. Number 4 is the Home Office's formal and polite response to the Law Commission. 5th of December 2016, it's a single page, doesn't advance matters much, but just a matter of formality, you should see that. And note in particular the final sentence on the first page of that letter of the 5th of December. Clear that there are matters to be considered about the wider regime, and I'll do so within the broader policy context and consider next steps as appropriate. But of more, so 49 is of rather more significance, it might be thought, and there are 2 other bits on the same theme of guidance to employers from government or from government contributing to this sort of guidance. The first of them in your little clip of documents, the new clip, I hope should be document number 1, which is MOJ guidance, which has sat and continues to sit on the MOJ website. And the relevant page in that document, it's headed, "This guidance applies from the 10th of March 2014. So this is guidance to explain about the new nuance scheme, the changes that were introduced post-T, as it were. And if you go to the penultimate physical page, you should have about an inch or so down on the page a bold capital title, number 4, information for employers. Have you got that? It's one page in from the back.
This is number one, is it?
This, I hope it's number one. The first page
Number
should,
one.
this guidance applies from 10th of March 2014.
Yep, it is number one. And I suppose it all depends on how you do the counting.
It depends
how
on how
many
you...
pages it is in from the back.
It is, but if we could find the page
I
marked
found information for
information for employers, number 4, one physical page in from the back. So my Lord Carers.
Yes, I've got it.
Have you got that? Sorry. Inconveniently not numbered because it's electronic, no doubt.
What should I consider?
Yes, that's the bit. The same list, is it? It's pretty much the same list, I think. And that guidance was before the court in W, and I think in P as well. So that's that. And then the next document, number 2, is a NACRO document. And this also is on the same theme and might be thought perhaps to be, in fairness, to be a rather more natural port of call for employers than the MOJ website. But the relevant part of this document, you'll see its title, Recruiting Safely and Fairly, a Practical Guide to Employing Ex-Offenders. And if you go to the foreword, which inconveniently isn't numbered, but it's one page in, you'll see at the bottom of that page, the DBS welcomes the opportunity to collaborate with NACRO and the CIPD. We're pleased to have been consulted on the guidance relating to the DBS checks required for this document. So some joint authorship or some at least consultative collaboration. And the relevant pages for present purposes are page 21, bottom right-hand corner, really through to the end of the first full paragraph on page 25. But you'll see there's an expanded list of things to be thought about by employers under the heading Assessing the Risk and Relevance of Criminal Records. And you see Best Practice Guide to Assessing the Link. You note the sort of questions that are contained there. Nature of offences is then analysed. Relevance over the page, at the top of page 22. Seriousness, age of offences, pattern of offence, I'm just reading the titles, changed circumstances and so on. Risk assessment interview on page 25. But you get some rather more detailed guidance in relation to that. So there is public guidance out there, either put out by government or in which government has collaborated, which provides equivalent, in effect, guidance to the guidance that exists in the Northern Irish system. And that is, we hope, of assistance to employers who are considering these sorts of issues. So structurally, guidance and assistance is in place. I do not accept that it would be proper for this court to proceed on the basis that there is clear and established evidence that there are a significant number of employees who'd simply refuse in the face of conviction to engage with that sort of process. And I make, if I may, a couple of points in relation to that. First, of the cases before the court, the indications, if anything, are the other way. The W wasn't prevented from getting on his training course, SFI, Statement of Facts and Issues, para 8. P was not prevented from gaining at least voluntary placements working with children, SFI, para 18. A, currently stayed but heard with P, is employed as a finance director and project manager and has not lost any job or job opportunity as a result of disclosure. See Lord Justice McComb at para 24. G withdrew an application for a certificate after learning what would be disclosed and did lose his job as a library assistant at a college, but never in fact gave his employer the chance to make a decision. See Mr. Justice Blake, paras 4 to 5, and G's case at paras 7 and 10, and he's currently working abroad. The position of Ms. Gallagher was, she had issued to her between July 2010, June 2014, some 9 ECRCs containing her convictions with no evidence that these prevented her from gaining employment. And she was employed at the time of the hearing, if I've understood it correctly, providing care to vulnerable adults. Secondly, many relevant employers will, of course, be public sector employers. Not all of them, but most of them, or a lot of them, will be. And they can be expected to operate reasonable and proper policies and to take into account the public guidance that is available. And thirdly, one cannot assume that paras 223 and 224 of the unlock intervention are representative or established as the evidential position. It's a bit difficult to engage too hard with that because the unlock intervention in that respect was not raised below, so there hasn't been an opportunity for response or testing of that evidence. I don't, of course, object to it going in, but there it is for what it's worth. Moreover, that paragraph, 223 of unlock, is not altogether consistent with other evidence in their submissions demonstrating employment of lots of conviction employees. See para 2.2 of their submission, referring to a May 2018 briefing and a May 2018 report, both of which are in the bundle Authorities tab 14, tabs 151 and 152. And in the earlier bundle, Authorities 13 at 136, MS 4852, you have the Director of Unlock stating to the Justice Committee, quote, "I would be the first to say that many people with convictions do secure jobs that involved enhanced jobs, having disclosed them, but that perception is not widespread, so they don't bother applying," was his evidence orally to the committee. And equally, we respectfully submit one needs to be a bit careful with the 2.24 case of unlock. We've included within the new materials a single page from YouGov, which appears, I think, to be one of the things that is referred to. But if you look at it's document number 3, it's a single sheet, YouGov DWP survey results. And you'll recall that the thrust of the unlock submission at 224 was that it's 50% of employers who definitely wouldn't. That's what the DWP data shows. But in fact, as you see from the actual data, that's document number 3, if you look, for example, at the last box and the titles to the left of it, it's dealing with offenders and ex-offenders. And then you look at the left-hand column in the bottom little table, would definitely not consider employing 18%, would probably not consider employing 31%, and so on. So one can argue the statistics, and we're not able to find the statistic that is then relied on by Unlock, that 75% of employers have discriminated against applicants on the basis of a criminal record anywhere in their report. So one needs to be a little cautious with those figures. True it is, no doubt, that one cannot exclude the possibility of individual employers being more or less hostile to a candidate with convictions or cautions which is current and is disclosed. But there is nothing, we respectfully submit, in that regard to be derived from Mr. Southey's reliance. You'll remember he took you to paragraph 45 of the Court of Appeal's judgment in T. Maybe worth just very briefly turning that up. It's 838 in the electronic, and it's behind tab 20 of bundle 3. 838 in the electronic, para 45. And you'll recall that he went to it with something of a flourish and said, well, there we are. There's the Court of Appeal relying on the government's own evidence in the form of Ms. Mason to demonstrate that the employer part of the system is a busted flush. But you will recall that that paragraph, it's referred to as page 20 in para 45, the reference to the actual, what is actually said by Ms. Mason, I just invite you to compare and contrast, Appendix 2D, electronic 7421, or manuscript in Appendix 2D 1298 in the hard copy, so 1298 in the hard, 7421 in the electronic. And the paragraph which is quoted is paragraph 89. You see the numbered page 20, the internal page numbering of 20, so you can link it back to para 45 of the Court of Appeal. But para 89 on page 7421 is the paragraph which is quoted. But it's immediately obvious when you place that in context that that opinion about the difficulties with the employee system leads to the conclusion that then follows in para 90 and the recommendation at 91 and in the box. And what actually happened, therefore, was that that opinion led Ms. Mason to, in effect, the current system. So there is no proper basis, we respectfully submit, for the assumption that this is, in effect, de facto barring. It is not. It is a disclosure regime in which the employer plays an important and legitimate part. And one should not lose sight of the fact that criminality has been committed and that the posts in question are, in the main, very sensitive posts in terms of the need for public protection. Third main topic, easy to come up with alternatives that would work fine.
Sir James, I'm assuming that you've
I'm going to
pinched
eat it.
some of Mr. Cole's time.
I am pinching a little bit, I'm afraid, with his permission.
Oh, of course, if he's happy,
I'm
we're
grateful.
not unhappy.
I'm grateful. Easy to come up with alternatives that would work fine. I made a series of submissions about that in opening. Yeah. I don't repeat their detail. It's the wrong question in principle for all the reasons I've repeated in reply. It isn't about whether some less intrusive scheme could be devised. There are serious issues on any view with impact on efficiency, speed, cost. I leave aside Mr. Owen's self-defining, self-financing point. Imposing a burden on employers does not, we respectfully submit, make it such, but leaving that on one side, those sorts of difficult impacts on the system, and ultimately it's a question of legislative judgments. What assumptions can you make about the numbers? There are two different bits of that you've received submissions on. Part one, if I can call it that, is how many may have to go through a reviewing system, if that's what you're thinking about. What does the evidence show you in relation to that? And the answer to that is that you have the sideways table that I went to in the core volume appended to our case on the cross appeal, and that shows that over the last few years there have been roughly 200 to 225,000 post-filter cases in England and Wales. And if you have a review system, that's the cohort, effectively. No doubt there would be some who wouldn't access the review, but one cannot assume that that would be a significant proportion of those who are covered by that 200 to 225,000 number. And that is a very significant undertaking if you were to have to set up a review to cater for even a significant proportion of those. Considerable resource, considerable delay, considerable concerns about how it would work and what would be required, and no doubt also the considerable opportunity for, as has occurred in Scotland, repeated challenges if you try to impose filters on the reviewing system to bring that number down to somewhere manageable. And in the end, all of that, in order to replace judgments about relevance, which we respectfully submit in principle, are perfectly properly left to the employer anyway. So that's the first part of what assumptions you make when testing whether review is necessary about the numbers. The second part of that game of numbers is Mr. Southey's suggestion that it is easy, the police can do it and they do it all the time, because they're always considering filtering back in. And my respectful answer to that is, first of all, that there are very serious questions, indeed, about whether they are entitled to do that, whether they can, as it were, filter back in convictions and cautions that have been filtered out.
This point would also be relevant, wouldn't it, to the question whether it's in accordance with law? Because if the submission is right, that anything filtered out can be sent straight back in again under 113.
And where's your control?
Then clearly the argument that there is a degree of discretion that gives rise to problems under that heading is rather stronger.
It is. It is, and my respectful submission is that it's extremely problematic in principle to see how that would work, because this is a highly prescriptive scheme. In other words, the filtering out bit is highly prescriptive. These are the things that have got to come out. These are the consequences if they come out. And quite difficult to see, or perhaps put it the other way, not at all difficult to see how you could mount a Padfield-type challenge in the light of that, in other words, coherence and consistency with the purpose of the legislation, given that it's highly prescriptive in nature, to see how that could be consistent to simply bring them back in, leaving aside the Article 8 points that my Lord raises.
It drives coach and horses through the elaborate categorisation.
It does.
Distinguishes between different degrees of gravity, antiquity, etc.
It does, but there is perhaps a more fundamental difficulty in terms of a pure point of interpretation, were the thing ever to be tested, which is that the short way of putting it perhaps is that the effect of the 74 Act and the 75 Order is to permit questions to be ignored and to prevent action by the employer in circumstances where things are filtered out. That's the essential effect of that. And the real question of interpretation that therefore arises is how it could be that under the 97 Act, 113B, the Chief of Police could conclude that it was relevant for the employer to know, that's the test, relevant for the employer to know about the conviction or caution that the employer could take no action over, because the same conditions apply. But however you do it, this is an unresolved issue of principle, and we respectfully submit, at the very least, highly doubtful. And so my learned friend Mr. Southey says, well, let's not bother about that, because I can make the case that this is all jolly easy by simply referring to the police's policy, which says, well, we do in fact do it. But at that point, you start getting into all of the debate around those numbers. We know from Mr. Ray's evidence, in a nutshell, that they include soft intel in, I think it's 9,000 odd is the consistent number. We don't know what the number is that were considered that led to that much smaller number. And that's when I intervened yesterday and you asked to see the FOI response. And that's I'm not going to take up time now, but that's the 5th document in your new little clip. And the relevant part for present purposes is on the 2nd page of that. And you'll see the 1 million number, which my learned friend sought to rely on yesterday. And you'll see the caveat, as it were, and it's no doubt one of a number of caveats that could be introduced, but you'll see at least that caveat. This is my electronic searching against the number of names point, just underneath the box.
Do they mean perimeters?
Parameters, I think. Do they say?
Well, they say perimeters.
Anyway, so one has that. Once you're in that little clip of documents, just to show you the last one, there was some interest expressed as to how much police actually know when they get these sorts of forms. And the 6th of the documents I've given you is the Disclosure and Barring Service application form. So that's the very last of the documents, and you'll see that there are, unless you're prepared to breach the boxes, perhaps the most relevant bit for present purposes, filled in by the employer, is on the final page of document 6. Position applied for, organisation named. You see that about a third of the way down, under apply for a DBS check. Position applied for is number 61. But that's the form. Anyway, So we respectfully submit that it's jolly difficult for this court to make any sort of assumption, really, about the ease with which that could be done because the police already do it. We simply submit that that simply is no way borne out, and the position is likely to be a great deal more complicated than that. Final point then on the easy to come up with alternatives that will work fine. Northern Ireland and Scotland, repeated reference to those in the submissions against me. Our short point on them is not comparable, simply a different scale, even if one could actually understand how the Scottish scheme worked. And my learned friend Mr. Southey's only answer to that was, yes, not comparable, smaller numbers flowing through the system, but, as he put it, less resources. I'm not entirely sure where he gets that from. There's no evidence whatever that the regions are in relevant part less resourced. So we respectfully submit that that isn't a good answer to my numbers point on Northern Ireland and Scotland. I turn then to Mr. Owen and international instruments, first of all, relating to children. We address those in the case. The short point in relation to those international instruments is that Mr. Owen nowhere identified any international instrument that imposes a binding obligation on the UK, whether directly or via the ECHR reliance on international materials, a binding obligation on the UK not to disclose criminal records relating to juvenile offending. On the contrary, recommendation R8720 expressly envisages the use of such records on compelling grounds provided for in national law. Paragraph 10 of the recommendation, authorities 13, tab 126, MS 4731. In particular, there is nothing in the international instruments relied upon by G to the effect that in no circumstances can children be treated the same as adults for relevant purposes under the scheme. True it is that lots of those instruments and lots of the case law emphasises rehabilitation as a virtue in relation to childhood offending, and entirely unsurprisingly. That, however, does not lead to any prescription in the context of a scheme in which public interests are in play. And there is a general point of real importance here. There has been an exclusive focus on the other side on their side of the scales, if I can put it that way. But one of the core and central aims of this scheme, let us not forget, when considering the rights of children in this regard, not, as it were, to disclose previous convictions or cautions or reprimands, a central part of those aims is specifically to protect children. And therefore, children's rights are very, very heavily in play on the other side of the scale. And of course, the scheme has differentiated for children. The currency rules, as you now recall, and I took you to Ms. Mason's evidence and specifically recognising the position of children, they were considered, their interests are weighed, and the result is that the currency rules differentiate. They differentiate both in relation to convictions, shorter period for children, and it might be thought to be particularly relevant because children may be thought to be inherently more likely to attract cautions or reprimands if they offend young, they differentiate in relation to cautions as well. So the scheme does differentiate for children, but needs to strike a balance inter alia in order to protect children. Then Mr. Owen sought to rely on the views expressed in various reports that had been made by interested bodies, and sought, as it were, to leave me lonely on Melancholy Hill. The short answer to that is not an unfamiliar place for government to be, I'm afraid. It is, of course, entirely proper for bodies to advance interests and to offer views and to invite consideration of reform. Some of those bodies, like the Standing Committee for Youth Justice, are not statutory bodies or parliamentary committees, but membership and campaigning bodies who perform an important and proper role in advancing the interests they seek to represent. But those are not a good indicator of incompatibility I can't, I think, recall of a single occasion in which reports of this kind in relation to almost any scheme have ever produced a report saying, congratulations, government, thoroughly well done. This is a marvellous scheme which works well. That is not their function, but the core point is that even if I am isolated and lonely, the fact of the matter is that that is not a good indicator of incompatibility, I respectfully submit. The relevance of disposal in G's case. G characterises his case as concerning the serious offence rule, quote, as it impacts upon convictions, cautions, reprimands and warnings acquired in childhood, but his oral submissions focused entirely on out-of-court disposals. And so we respectfully submit juvenile convictions are of considerable potential importance, at least. And we do respectfully invite the court to conclude that this scheme does differentiate and does differentiate properly in relation to the position of children. Finally, remedy, and very briefly remedy. I don't need to take long in relation to remedy, but the position is that it's only faintly asserted, if asserted at all anymore, that you should strike down the 1975 order in its entirety. Of course, the difficulty with that submission is that precisely the same submission was made in T and didn't find any support amongst the court.
Well, it was met with a very powerful intervention from the Financial Services Authority.
It was, and that the outcome of that was reflected, I think, in both of the main judgments. I think you were taken in this respect to Lord Reid exclusively, but Lord Wilson had plenty to say about it between paras 59 and 65. Of course, no one disputes that the correct remedy in relation to the 97 Act is a declaration of incompatibility, and what therefore that leads to is a real problem of interlinking the 75 order and the 1997 Act. So you could end up in the position, if you do start striking down bits of the 75 order where you have an incoherent regime, all of that feeds it because material is being produced to the employer, which the employer can't then take into account. It becomes a strange old business. So that is one reason why we respectfully submit that declaratory relief, identifying the concern that the court has, is the right way to go, is the right answer, and then Parliament will need to think again about how it deals with that. So that's one reason not to go down the road my learned friend Mr. Southey's invited you down. The second reason, of course, is the one given by Lord Wilson and indeed Lord Reid in the judgment in T, which is that you are dealing with, if you focus, for example, on the two conviction rule, you're dealing with a rule which is not, as a rule, problematic. And I put it that way because there will be many cases in which two or more convictions can entirely compatibly be disclosed under the regime. What that demonstrates is that the question of the appropriate remedy starts with the incompatibility you've identified. If the problem with this scheme is that it doesn't have a review in it, then you haven't got a problem with the two conviction rule, you've got a problem with the lack of a review. So you don't strike down the two conviction rule to deal with the incompatibility found if that's the basis for the finding. But even if the problem was the existence of some cases, some individual cases, in which there is a problem with the two conviction rule applying, you still don't strike down the two conviction rule because it can perfectly contentedly operate in a large number of cases. So again, that leads in the same way to a remedy that says don't strike down that bit of the legislation even though technically it's open. I should add that there is nothing in the point that I think my learned friend Mr. Southey was almost submitting was the position. There's nothing in the point that says, if this was a submission, that the Human Rights Act, as it were, precludes you from making a declaration in relation to secondary legislation. Of course, the rules are different under the Human Rights Act. And the difference is that under the Human Rights Act, if you make a DOI under Section 4, Declaration of Incompatibility under Section 4, the effect of that is to open up the remedial order curing of that found incompatibility. You don't have that option. You don't have that consequence in relation to secondary legislation. But as the court pointed out in T, you don't need it. You can simply make a declaration under the general discretion to give whatever remedy you consider to be appropriate.
Is reading into a piece of subordinate legislation an alternative way of dealing with it?
Well, you can try and do that, but of course, if you do...
If practical.
If practical. But the difficulty, of course, as you confront there is all that case law on the divide between Section 3 and Section 4.
Yeah.
You can do that which is possible, but the limits of what is possible are both issues of interpretation and issues of constitutional importance. See Poplar Housing, Gardner Mendoza, all that line of case law on that divide. So we respectfully submit that for all of those reasons, the appropriate and correct remedy is at most to declare and then allow Parliament to deal with how you marry up the 97 Act and the 75 Order and what to do about the incompatibility which is actually found. Those are my submissions, unless I can seek to assist further.
No, thank you very much indeed.
My Lady, my Lords, I think that leaves me with probably around about 10 minutes.
I think you've probably got, yes.
So
yes.
Here's
9 or 10.
9 or 10.
Here's hoping. First of all, can I say that I gratefully adopt again the submissions that my learned friend Sir James has made in reply, and I will studiously, particularly given the time I've got left, try to avoid repeating any of those. In relation to the point made yesterday against my case, against the Department of Justice, and the move from the Northern Ireland criminal record regime proper, Causeway as it was called, to using the Police National Computer, with the implication that that reduced down the category of materials that were searched against and to simply those which are recordable offences. My friend Mr. Wolfe, in fairness and not perhaps surprisingly, suggests that that is an indicator that the regime that went before was too broad, and that too broad regime impacted negatively on Mrs. Gallagher. What I'd simply say in respect of that is that the move to the Police National Computer, with the implication of a reduced category to recordable offences, was primarily driven by practicalities that were faced by the department. Time doesn't allow me to take you through this, but if I, for reference sake, could say that at MS 8411 to 8412, within our core bundle, in the appendix, page 216 of the appendix, paragraphs 33 to 36 of Mr. Clark's affidavit, you can see set out the basis of the reasons why the department was faced with that reality. The implication of that, of course, for Mrs. Gallagher is that going forward, she receives the benefit of that, because as we know, her offences being non-recordable will now never show up on her EDC in the future, and have not shown up on her EDCs since the operative one in this case. So she has the benefit of that. It's simply that, a boon to her. It's not something that should be used as a stick to beat the department with. Beyond that, we could say it is clear, categorically clear, that those non-recordable offences will not show up on her EDC in the future, has not done so to date since the change. It's already been removed from it, and you can see Mr. Clark addresses that as well. It's further tolerably clear that the PSNI, Police Service of Northern Ireland, have not moved to re-enter that type of information in respect of Mrs. Gallagher through the police relevant information section of the EDC, because she's had EDCs since the operative one in this case, and it has not been present upon it. So we say that that point really falls away. The concern that apparently exists falls away. My Lord friend Mr. Wolfe, again understandably, made some hay out of the exposition of the position behind the department's thinking of moving both to the filter regime and to the review regime that came into place thereafter as well. And perhaps somewhat unusually, there is reference within the open materials provided to the Justice Committee of the Northern Ireland Assembly to aspects of the legal advice that was provided to the department by the Attorney General for Northern Ireland at the time. Somewhat cautiously, perhaps could I say that in respect of this, it is only legal advice. That is not in any way to denigrate the advice provided by the attorney, but it does not amount to the weight of a court judgment. And one can see, for example, at MS 8523, that the exposition of it is given in somewhat differential terms. It might, the absence of a review regime might render the regime unlawful. Of course, truth be told, it's really the outcome of this case that will inform us as to whether in fact that is right or not. One might say that the attorney could be accused of adopting a precautionary approach in that regard. Again, we say it should not be used as a stick to beat the department with, that there is now a limited review regime, but there was not in relation to Mrs. Gallagher's case. And I remind the court that the review regime that is in place now in Northern Ireland is, while a useful progressive step, it is limited. It does not address itself at all to unspent convictions, which, as the court will know, can cover a wide gambit of convictions. And in Northern Ireland, any conviction for which there was a sentence of imprisonment for more than 30 months will never be spent. So the review regime is useful, but it is of a limited remit and designed specifically with that in place. The position is that there will continue to be cases at the margins where the work of the independent reviewer will not result in expunging of criminal record information. And our point about the importance of the role of the employers remains sound in those circumstances. The employers will still be provided with information, and it will be for the employers, with their close knowledge of the role and of the risk factors arising in connection with that role and what they know about the ex-offender, to make the decision about suitability for that particular post. That is something that's very difficult to replicate, even in the context of the current review system as it stands. My learned friend Mr. Wolf further made the point that in the context of Mrs. Gallagher's case, that the employers didn't see any significance in the disclosed convictions. And he uses that in a sense to suggest that, again, it's an indicator that the scheme is imbalanced. We say that in making that point, the respondent is effectively trying to ride two horses at the one time. In effect, they say it's wrong to disclose because of the potential negative impact, particularly on Mrs. Gallagher's future employability. But yet at the same time, they say it's now wrong to disclose because employers aren't interested in the information. And we say in response to that that it cannot simply be the case that a disclosure made under whatever regime may be constructed could only be lawful if it results in an employer making a non-employment suitability decision. It cannot be the case that it would only be lawful to make the disclosure where it does actually act as the metaphorical albatross around the respondent's neck. Furthermore, it's argued on behalf of the respondent that while her breach of trust in not providing the proper and full information to the Western Health Trust is that which operatively led to the removal of the job offer, she shouldn't have been in that arena or in that, have to operate in that context in the first place, because the scheme should not have put her in that context. And respectfully, we say that that is an unattractive argument that effectively equates to saying, I shouldn't have been in a position to commit a breach of trust. The fact is that the scheme was and is the scheme. She was required by law to comply with it. She didn't do so. It is not a good point to excuse that failure to say, well, it's a bad law. Can I say something very briefly about remedy and relief? I specifically adopt the submissions made very laterally by Sir James in relation to the relief aspect and adopt them into the Northern Ireland context. Additionally, I can say that the Northern Ireland courts have adopted what might be described as its well-known Irish pragmatism in how they've dealt with the remedy issue in this case. At the High Court stage, the parties post the original judgment of the High Court invited the court to consider what orders it might wish to make. And Mr. Justice Tracy, as he then was, refrained from the making of any specific interventionist orders. That position has in fact been upheld and remains the position post the Court of Appeal as well. So, in
Well, I
effect,
was looking for court orders,
yes. Well, the court orders. Yes,
failing to find them.
they're at, the Court of Appeal's order is at MS 8195, and the two High Court, as you will recall, that this case had the benefit of 2 trips to the High Court, and the High Court orders are at 8231 and 8255.
Just give me those again, please.
Yes, certainly, my Lord. The Court of Appeal order 8195.
Yes, I've got that.
And the High Court 8231 and 8255.
Thank you.
What is the substance of that?
Court ordered that the appeal do stand for judgment.
That's right. And if
Dismisses the appeal.
they were really, in
Doesn't
effect,
say anything really.
they were akin to declarations without saying they were declarations. And in essence, really, the judgments have been left to speak for themselves, and the authorities, depending on the outcome of this appeal, will react or not have to react, as the case might be, to the...
So there's no declaration of anything?
No, my Lord, no interventionist declaration.
I would say interventionist.
Well, in the sense that there was no striking down...
Anyway, that's the position that we've got.
Exactly.
There's no declaration.
Yeah.
And you're saying that even if we dismiss the appeal, we should take the same position?
I respectfully invite the court to take that sensible and pragmatic approach. And I say there's a further reason why I say that should be the approach. As indeed Lord Kerr made the point yesterday, in Northern Ireland, the 1997 Act, as it applies in Northern Ireland, has in itself moved from the position that applied in Mrs. Gallagher's case. So, on 2 grounds. One, I'm repeating myself, I'm afraid, but we no longer obviously have the non-recordable offences, and as we know, she falls out of the disclosure regime because her offences were non-recordable. Secondly, there is the review mechanism that's in place now also as of 2016. In relation to the rehabilitation of offenders...
So, I mean, you're saying, really, that no order is necessary because of the twin facts that she's no longer caught,
yes,
and the law has moved on.
Effectively, that's right, yes. On that limb of on that pillar of the scheme. In relation to the rehabilitation of offenders order, again, my general point is that the court should find it attractive to say whatever it has to say about that, but not to intervene and have the potential wider spread impact of going beyond that which is strictly necessary. The point made by...
Well, at 8256, Mr. Justice Tracy is recorded as holding that the 1979 order violates Article 8.
Yes.
That's as near to a declaration as one can...
His order reflects the finding in his judgment in that regard.
Right. He holds that. It's pretty close to declaring that that is so, isn't it?
Whereas his first order, the one that went to the Court of Appeal, simply said that the application for judicial review be allowed.
Yes. When we come back on
a strange sort of order to English eyes.
It comes back to the point I make about the famous Irish pragmatism sometimes to these approaches, and the judgments reasonably often were left to speak for themselves. Not all the time, of course.
I'm not so sure about that.
Well, I defer to Lord Kerr about that, but can I say in relation to the rehabilitation of offenders order, I specifically agree with the point made by Sir James that it will not always be the case that the multiple conviction rule, which is obviously the issue that's in play in my case, will be incompatible, even if there is a finding that in Mrs. Gallagher's case it wasn't to be incompatible. If you were so minded to strike into the order and to try to cut elements of it down, we respectfully suggest that the relevant provision to be addressed in that regard is in the 1979 exceptions order, found at tab 6 in volume 1 of the authorities bundle, and it's Article 1 capital A, brackets 2, brackets C.
What's the MS number,
The
please?
MS number for that Lord is MS 428. And I've also had the opportunity to speak briefly this morning with my learned friends Mr. Wolfe and Mr. Coyle about this, and I think it's fair for me to say that they agree that if you were to intervene into the rehabilitation of offenders limb, that is the provision that you might most particularly address any striking down to.
Can we just have it again?
Yes, of course, Lord. It's Article 1, capital A,
Yeah.
brackets 2, brackets C, of the 1979 Rehabilitation of Offenders Exceptions Order, and it's at Volume 1, Tab 6, MS 428.
That's the two offences rule, is it?
It is, Lord, yes. Two further points, if I may, very briefly. One is that in a different context of review, I think I made the point in my main submissions earlier in the week, that the Northern Ireland authorities do not consider this scheme to be cast in stone forever and a day, and they do intend to conduct a review, and the intention has been, I should say, to conduct a review of the scheme, both pillars of the scheme, and particularly now in light of what judgment will come from the court. In relation to the current absence of an internal review process in the Rehabilitation of Offenders limb, while it may be the generalised intention to try and catch up with the Access NI disclosure regime review process in that regard, one might flag up some potential practical difficulties that will make the construction of any review scheme in that side of the House a matter of particular consideration. In the review that's currently in place under the disclosure regime, it is possible for the reviewer to obtain information relating to that specific post. So there will be an application countersigned by a registered body for a particular post, and the reviewer can take that into account in deciding the proportionality of any disclosure. In other words, the reviewer can get closer to the detail. That will not necessarily be as easy to replicate when one is looking to the Rehabilitation of Offenders Order, for the practical reason that when one's applying for a job, the timescale for it may be reasonably limited. It might be a matter of a couple of weeks. It will not be likely very feasible for a potential applicant for a job to at that point go to some kind of an independent reviewer and in that timescale have the information reviewed against the specifics of that post. So what is more likely is that there will be a dislocation or a distance between the review and that side of the equation. It will operate at a higher level and it will have less direct connection to the post in place. That might be unavoidable. It potentially also serves to lessen the benefit of any review process to a potential applicant, because the precautionary principle is likely to still prevail, and the reviewer will not likely remove anything until and unless he is satisfied that it does not undermine public safety. Final point, it was suggested yesterday that there is a great interest on the part of the police service generally in taking on elements of this role that are currently conducted in Northern Ireland by Access NI. From our specific outlook in the Northern Ireland context, we can, I think, say with some degree of certainty that it is difficult to ascertain a clamour amongst the ex-offender community in Northern Ireland for the PSNI to take on this role in addition to their already very onerous roles. It seemed to us that the direction of travel in the future will remain with Access NI and the Department of Justice. Lady, my Lords, unless there's anything further, I'm not sure whether I complied with the 9 or 10 minutes.
You didn't. You just about doubled it, I think.
I will, unless there are any further specific issues, I will gratefully sit down.
It would appear not, Mr. Cole. Thank you very much indeed. Mr. Southey.
My Lady, my Lords, before I just deal with my very brief reply, and it is going to be very brief, can I just raise two matters? One, I think I promised my Lord Carnworth a note dealing with the Scottish system. I had hoped to have that available today. What instead, though, I think we've taken the view would be perhaps of greater assistance given the complexity is if we could agree that with the other side. And we've given a draft note dealing both with that and the Law Commission response to the appellants to allow them to consider it and see whether or not we can agree a position given the complexities of the Scottish system. I think hopefully that will be of more use to the court than sort of two sets of submissions about how the Scottish system works. The second point that I'd like just to raise before reply is this. My learned friend handed up two, and I make no complaint about this, two fresh policy documents, one from the MOJ and one from NACRO. There is one brief point I ask for the leave of the court to raise in relation to that, and that's this. Those documents are not statutory documents. I drew attention yesterday to the fact that there is a statutory mechanism essentially for holding employers to the statutory guidance. The National Audit Office report obviously indicated in practice that mechanism may not be applied, but there is a statutory provision which says essentially employers need to be aware of this. There is nothing that requires employers to be aware of this guidance, nothing that indicates to employers that if they are aware of the Act, it even exists. It is ultimately a matter for employers whether they take any notice of that guidance at all. Can I then turn to the reply? In terms of remedy, can I start by pointing out what my learned friend didn't address or didn't explain? If one starts from the position, which obviously we say is correct, that the two-conviction rule is either disproportionate or not in accordance with the law, the question then arises is how, under the scheme of the Human Rights Act, was it lawful to enact that rule? In our submission, it simply can't be lawful because the Human Rights Act doesn't permit the making of secondary legislation that is in breach of the Human Rights Act. Now, if that means the two-conviction rule is unlawful, it means it's ultra vires. And in our submission, the court has to provide relief that makes that clear. Because people subject to the two-conviction rule need to know whether they are obliged to reveal their conviction. That's the armoured point. One can't fudge the issue. Either it's lawful and people still are subject to the two-conviction rule, or it's unlawful. There's nothing in our submission in between. Now, what are my learned friend's answers to that? Well, he says there's a risk of incoherence. Well, firstly, in our submission, it's a little unclear what that incoherence is. The prescribed, if one in particular strikes through or strikes out the two-conviction rule, the prescribed questions still exist. That's what the Act requires for the Act to work. There's no problem with that. It's true, I accept, of course, that one can get in a situation where someone is in a position where they don't have to disclose their conviction themselves, but it may be disclosed under the Act. But that's still a benefit to the individual because employers don't have to seek criminal record certificates. Employers may not. I can see my Lord Hughes.
I thought some did.
Some do.
They do in relation to certain employers.
No, some do, but some don't. I mean, I can give an example a personal example that I'm very familiar with. I've just effectively finished as chair of the management committee at Matrix. Matrix could seek enhanced criminal records checks because we have personal details of the judges, because a number of members of chambers are part-time judges. And one of the provisions that allows one to seek a criminal records check is that you have personal details of judges. Now, never happens, but in principle it could. So there is a benefit to people. If they're not, because not every employer will seek an enhanced criminal records check or a criminal records check at all. The second point that my learned friend, so incoherence in my submission, but in any event, fundamentally, with all of these points, I come back to the basic point, which is either it's a lawful provision or it's not a lawful provision. The second point my learned friend says is, well, the two conviction rule can operate in a number of cases without breaching Article 8. But again, the problem with that is the act under the Human Rights Act that effectively is challenged in relation to the order is the making of the order. And either the order was lawful or it wasn't. The reason we drew attention to declaration of incompatibility was not primarily because essentially one would be needed in this case, because I recognise obviously the legislative process is different in relation to primary legislation. It is because it demonstrates that there is a coherence in the Human Rights Act. Primary legislation is the way in which Parliament legislates if it wants to act in a way that's incompatible with the Human Rights Act. Secondary legislation is not protected in that way. And that's why I was focusing on the absence of a power to make a declaration of incompatibility. In my submission, it supports the argument that there is no basis upon which one can conclude the order is lawful if it breaches Article 8. The final point in terms of reading in, my Lord Hughes asked about reading in. We don't dispute one can read in principle. The problem is that certainly the courts below were of the opinion one couldn't read in, of course, in relation to the two conviction rule, because it's clear. It's effectively completely eliminating the rule, and that's the problem. So that's why I think it's not being suggested in practice one can read in. There's no reason in principle, certainly, why one can't read in. Hopefully, I think that's all I need to say, unless I can assist the court further.
I think not, Mr. Tully. Thank you very much indeed. Thank you to everybody for all your hard work in producing all of this material for us to think about on all of these issues, about all of these cases. We will now go away and give it our best shot and let you know in due course. The court is now adjourned.